Welcome to this episode of Litigation Briefs, media shorts on law and courts. I'm Scott Dodson, a distinguished professor of law at UC Hastings College of the Law and the director of the Center for Litigation and Courts, which produces this series. The Supreme Court is constantly in the limelight, and no one doubts its importance. Despite Alexander Hamilton famously calling the judiciary the least dangerous branch, the court has always been under fire for its seemingly politically partisan decision-making. Recently, however, it seems that appointments to the courts are more polarized than ever. Antonin Scalia and Ruth Bader Ginsburg, political opposites, were confirmed by the Senate with 98 and 96 yeses, respectively. That kind of agreement on the court seems like a pipe dream for the Senate today. With recent confirmations along narrow party line votes, the perception of the court as a neutral, apolitical institution of justice rather than of ideology has faded. Can the court's image be saved? And how might Congress do that? Here to help me with these questions is my guest, Dan Epps, a professor of law at Washington University Law School and the co-author of a recent paper titled How to Save the Supreme Court. Dan, welcome to the show.
Thanks so much for having me, Scott.
Let's start with a bit of background on the court and the Constitution. What does the Constitution prescribe about the court?
So honestly, not that much. The Constitution says federal judges, including Supreme Court justices, shall hold their office during good behavior. Doesn't use the words life tenure, but that phrase has been understood as meaning life tenure. Constitution mentions that there will be a Chief Justice of the United States, but then doesn't specify anything about the court's size. So it's up to Congress to decide what the court's size will be. And it's also up to Congress to decide what the Supreme Court's jurisdiction will look like. What kinds of cases does the Supreme Court get to hear? What kinds of cases does the Supreme Court have to hear? So there's a lot that's underspecified, but then there's a lot that what you might describe that's the product of conventions, the way that it has always been done or the way that it's been done for a very long time. Constitution, as I said, doesn't specify the court's size, and the court's size has changed, has been manipulated at various points in American history, but it hasn't changed for more than a century and a half. And so a lot of people look at that and they say, well, sure, Congress technically has the power to change the court's size, but that's a real kind of political third rail. Let's stay away from that, especially doing that for partisan reasons. That would really set off everyone's alarm bells. But there is, I think more flexibility there and less that's specified than people really assume if they don't know exactly what the Constitution says.
Great. So the protection of life tenure and I think the appointment process has kind of led to some charges that the court has been overtly political in its decision making. And I think the result has been some intense scrutiny of nominees to the court. Can you say a little bit about those charges and the current image of the court?
Yeah, so let me say at the outset why I think this arises as a problem, which is that the court is relatively small. It's been set at 9 justices, as I said, for a century and a half. And you combine that with life tenure. So justices sit for life unless they're impeached, which is very, very hard to do. Impeached and removed, very, very hard to do. And they're staying in office for longer and longer as people are living longer, as justices are maybe appointed a little bit younger. And then finally, the combination of fixed size and life tenure means that vacancies are somewhat unpredictable and random. They're a product of 2 things, which are one, sort of strategic retirement, justices going out of their way to leave office during conditions when a president and Senate, who they sort of view as congenial, are in a position to confirm ideologically similar replacement, but also is driven by unpredictable things like when people get sick and die, as we saw with Justice Ginsburg's untimely death just a couple months before the 2020 election. And what that means is any given vacancy is extremely high stakes and has the potential to really shift the law because Supreme Court, is really a very powerful policymaking institution, put aside questions of whether you think we should think of the court as just doing law, or really just doing politics and policy. It is clear that who's on the court matters a lot, that they're really important questions the court decides that ultimately are going to be a product of its membership. The court isn't divided on everything along ideological lines, but some of the most important questions divide the court on ideological lines. And in my work with Ganesh Sitaraman, we have highlighted these trends. We've noted how the process is getting increasingly polarized. We've noted how the legal universe, American law is becoming increasingly polarized. We have two different, basically competing approaches to law, and we're starting to see more and more voting that really lines up with partisan identification. And when we wrote our article, it was published in 2019, we noted that with the appointment of Justice Kavanaugh, you had a court where ideology matched partisanship for the first time, really, in American history, as my colleague Lee Epstein, who's an expert on the sort of empirical analysis of the Supreme Court and Supreme Court ideology. And we argued that's troubling, and we argued that that is going to really harm the legitimacy of the court, particularly as the court, reaches results that really track partisan identification. It will cause the court to be viewed in sort of, we predicted in a way that sees it as a more political institution. This is ultimately inconsistent with the idea of the court as doing something different than pure politics, and we think this is harmful to the rule of law. Now, that's a prediction, and I think some people say, oh, let's look at the court now. Approval rating is not that much harmed. Maybe it takes a dip when there's a contentious confirmation, then it goes back up. But I think our view is that it's going to be dependent a lot on what the court does. And something that we have seen historically is the court does kind of pull back from the brink, doesn't go kind of over the partisan abyss. People on the court moderate, even if not everyone in the court moderates. And so in part driven by institutional considerations. And so I think at this moment, I'm not going to say, the court's legitimacy is destroyed. I think that's not something that I can establish consistent with where we are in terms of public opinion. But I think it's plausible to think we may be at the calm before the storm, that the court really has justices who are much more conservative and much more kind of partisan identified as well. I think that's a fair thing that one can say about the Democratic appointed justices as well, that in many cases, important cases, their views kind of line up with partisan ideology. But the court might be about to embark on a really significant project of moving the law in a conservative direction and moving the law in a direction that is congenial to the National Republican Party. And if that comes to pass, if the court doesn't kind of pull back, I do think that we're going to see some very troubling results in terms of how the court is perceived and whether it is perceived as a purely political institution or something else.
So I do want to get to your preferred suggestions for how Congress might reform the court. But before I get there, I guess I'd want to ask you, what are some other sort of current or in vogue proposals for reforming the court?
Yeah, and this has been an area that's just full of discussion recently. I think that the idea of structurally reforming the Supreme Court had not really been something that was seriously talked about until a few years ago. There had been a fair amount of discussion in recent decades of term limits proposals as the main one that got some consideration. And the idea behind a term limits proposal is, and this is the most common version, although there are some other variations, is that each president would get to make 2 appointments to the court, one every 2 years. And those justices would serve for 18 years, staggered, such that the result is basically you have one justice shuffling off the court every 2 years, a new justice joining the court, 2-term president gets to appoint 4, 1-term president gets to appoint 2, and so forth. And there's some details of how you design it, but the basic idea is This eliminates strategic retirement. This eliminates the court's membership being kind of the contingent result of when people die and so forth, and makes it correspond a little bit more to the results of elections for president and for Senate in a more predictable way. And my view is that reform, would probably be better than the current system, where it really is kind of random. You can have President Trump gets 3 appointments to the court in 1 term. President Obama gets 2 in 2 terms. President Carter gets none in 1 term. President Ford gets 1 in less than a full term. And I think that would be an improvement. And it has this sort of appeal. It sort of seems bipartisan, doesn't seem to favor one side politically. And there's been a lot of discussion about that. There are versions of that reform that attempt to implement it via statute rather than constitutional amendment. And that's why it's important that the Constitution doesn't say life tenure. It says during good behavior, and there's different views on how to interpret that. Some people think that as long as the justices keep their offices, keep getting paid, and can still sit on lower courts after 18 years, it's fine. A lot of other people say that's clearly unconstitutional, but there have been efforts to do that. And in fact, there's Democrats in the House have actually put forward legislation that would do that by a statute. But there are other proposals. At the other extreme end, in terms of less bipartisan, less good government, more kind of partisan, is the idea of court packing or court expansion, depending on how you want to label it. And this would just be Congress enacting a statute that says now there are, 13 seats on the court, 15 seats, whatever you want. And here there has been a proposal that put forward by Democrats, both in Congress and the Senate, to do that, to create 4 more seats that would President Biden would be allowed to fill. And the idea for this is kind of retaliation. This is kind of making right what went wrong with how the Republicans handled Supreme Court nominations at the end of the Obama presidency, when they refused to let Obama appoint someone, and then at the end of the Trump presidency, when they allowed President Trump to appoint Justice Barrett mere days before the presidential election. And so appeal of this is that it's pretty clearly constitutional. As said before, the court size is not specified in the Constitution. So clearly there's a role for Congress in setting the court size. Congress has manipulated the court size. Previous points in American history, most people argue that when the court did so, it was for political reasons and not just for sort of neutral good government reasons, although there's a little bit of a historical debate on that. Josh Braver at Wisconsin has argued that that's not the case. I'm not going to settle that here, but it does seem like even if it's a partisan move, it probably is constitutional. It's hard to come up with a theory for why that's unconstitutional. But it's seen as just a partisan power grab. And the argument against it is it would delegitimize the court quite significantly, and it would create a battle of retaliation where the other side would feel the necessity of packing back once it's in power. And then there's a range of other proposals, some sort of tinkering with the court's certiorari process. One would be limiting the court's jurisdiction, what we call jurisdiction stripping. As mentioned earlier, Congress has power to define the Supreme Court's jurisdiction. And so in theory, Congress could say, the Supreme Court just doesn't get to decide certain categories of cases. We're going to let the lower courts decide that, or maybe we'll just not adjudicate those in the federal court system at all, and just sort of get the court out of this field. And that's a possibility too. There's upsides and downsides to that reform, but those are some of I'd say the leading contenders in terms of reform.
Great. And so what are your suggestions for how Congress can save the court?
Yeah, so Ganesh Sinnaraman and I put our heads together a few years ago and sort of said, look, this is something that people are going to be really thinking about in the coming years. The way the court has been handled politically and the stakes involved are going to make it such that Democrats are going to really start asking questions that people haven't asked in many, many decades, since the 1930s, when in 1937, President Roosevelt proposed a plan that would have allowed him to name as many as 6 additional justices, driven by his dissatisfaction by conservative rulings limiting his New Deal agenda, although he didn't frame it to the public that way. That plan was ultimately defeated politically, sort of seeming to seal this norm that you don't mess with the court size. But now all of that stuff is back on the table. And so we sort of said, look, here are the different proposals that are floating out there. We see them all as kind of imperfect in some way. We see objections to term limits. One objection is, it could change the justices' behavior, could actually make them more partisan, and actually makes elections even more focused on the Supreme Court than they are right now, because you always know ex ante there are 2 seats on the court at stake. There could be, the court could be 5-4, the 5-4 majority could hang in the balance with every presidential election, and that might actually raise the political temperature. Jurisdiction stripping, we see a lot of practical problems with that. And court packing, we note the objections that it really could result in a court that is seen as purely partisan and could diminish respect for the rule of law. So we said, what are some ideas that we could put forward that we think could actually restore some kind of sane equilibrium and maybe be something that ultimately both sides in the political process could live with, even if it's not everyone's first choice. And we actually came up with 2, in part because we weren't, totally confident in what the one right answer is, but also as a strategy of sort of showing people, let's think a little bit outside the box. Let's think more creatively. And so one of them we call the lottery court. And the idea there is just expand the court in this way, make every judge of the Court of Appeals also formally designated a Supreme Court justice. The court is going to sit in randomly drawn panels. Although we may tinker with the randomness a little bit to ensure some level of partisan balance to prevent extreme ideological skews between panels. Panels that select the cases are not going to be the same ones that decide those cases, and so there's a little bit less of an agenda-driven Supreme Court. And the relationship between appointments and outcomes is much more contingent. A Court of Appeals judge is going to decide some cases on the Supreme Court, but you don't know, okay, now we're replacing the swing justice, and now we can do all this stuff we want to do. The other one we call the balanced bench, and this, for whatever reason, this one has gotten a little bit more play. It ultimately was the proposal that Mayor Pete Buttigieg, as a presidential candidate in the Democratic primary, endorsed and really got behind and gave us a lot of attention, boosted our SSRN downloads, for which we're grateful. And the idea here is it's really an analogy to one common system in civil arbitration. That's where the original idea came from, and we were thinking about it. And in that system, you have kind of 2 sides have a dispute, and they each pick an arbitrator, and the 2 arbitrators agree amongst themselves to pick a kind of a neutral. And we said, that seems like kind of a good system for a situation where we have these 2 kind of warring ideologies and no likelihood of kind of common ground super soon. So let's design the court this way. We'll have 15 justices. 5 of them will be in some way kind of reserved for Democrats, appointments by Democratic presidents and so forth. 5 of them will be in some way reserved for Republicans. And there's different ways mechanically to do that. But then for the other 5, so you've got 10 total, 5 and 5, the other 5, the justices are going to have to collectively agree amongst themselves to designate certain Court of Appeals judges to sit with them by designation for a year. And if they don't do that, they just don't get to decide cases at all. And the rationale for that being that the incentives there are not to pick the most ideologically extreme, but actually pick among the pool of Court of Appeals judges those that are seen more as kind of middle of the road, moderate, straight shooters, not ideologues. And basically, this is what we call like a power sharing system. Basically, we recognize the court is a really powerful institution, and rather than just continuing to fight over who gets the bare majority, let's just kind of divvy it up, and then we can maybe stop fighting about it politically so much going forward. For both of these proposals, there are, and I won't minimize them. There's serious constitutional objections to them. Our goal was to show that there are at least plausible arguments for why these aren't unconstitutional. There's many things in current law that sort of look like this. And we could imagine a world where Democrats sort of, rather than ramming through court packing, they say, look, let's try something that looks like this. It's a little bit more of a good government type reform, and that ultimately maybe could produce an equilibrium that people can live with, even if it's not everybody's first choice.
That's really interesting stuff, Dan. Thanks so much for being on the show and for helping us understand how Congress can fix the Supreme Court.
All right, my pleasure. Thanks, Scott.
This episode was produced by the Center for Litigation and Courts at UC Hastings College of the Law. If you enjoyed this episode of Litigation Briefs, I hope you'll tune in to future episodes. In fact, I hope you'll consider subscribing to our YouTube channel and audio podcast, which can be accessed through the center website at sites.uchastings.edu/CLC. While you're at it, encourage a friend to do the same. This is Litigation Briefs, respectfully submitted, Scott Dodson.